Okay, so hi everybody. This is an exciting panel because work is personal to everybody. Work is so interesting because it's so personal, yet it's just an economic exchange. And anyone who works in this space, either about AI and the law, or employment law, or labor law, knows how deeply personal these issues are to the people involved. So I really love this space, and hopefully you'll find this interesting too, since probably most of you in the room work. And can take it personally as well. So I'll just introduce myself and then turn it to my esteemed colleagues to introduce themselves. I'm Zev Eigen. I work with DLA Piper in the AI testing group, and have been a law professor in my career for a little bit, and a business school professor. Have practiced labor and employment law, both in-house and out-house, as I like to call it. And also have founded two HR tech companies, one that predicted recidivism, and another called Syndio, most recently, that has helped hundreds of thousands of people get paid fairly and equitably. It's a workplace analytics company, SaaS company. Let me turn it over to Professor DeHaan.
Hi everyone, I'm Samuel. I'm a law professor at Queen's University. I'm the founder of Open Justice. It's an open source legal AI creation community. And until recently, I was the head of research at Deal, an HR tech company.
Hi, I am Vina Dubal. I'm a professor of law at the University of California at Irvine, where I write at the intersection of law, technology, and precarious work. I have a joint appointment in the anthropology department, so really think of myself as both a social scientist and a law scholar. And I'm also the general counsel for the American Association of University Professors, which is the largest and I think one of the oldest organizations in the U.S. That has been established to protect academic freedom and shared governance on university campuses.
Okay, so let's start off with a nice, easy softball question. Once AI replaces all of us in the workplace, how likely do you think it'll be that the male robots will get paid more than the female robots? Or put another way, if AI just completely replaced all the HR function today, would we humans be better off or worse off?
Where do we want to start? Hiring or compliance? Do you want to start?
Sure. I mean, I think it was around 2016 that there was this article by two Oxford economists about how so much of the work in the U.S. and in global North countries was able to be replaced by and through machine learning systems. And many of us since that time have grown quite skeptical of this narrative that our jobs are going to be replaced by robots, and much more concerned about the ways in which our jobs become our job quality, our working conditions, our wages become atrophied through the use of particular kinds of AI systems. So, your specific hypothetical, which is, I think it was made in jest, how long before the male robots make more. One of the things that I have identified and write about is this emerging practice of the use of machine learning systems to set salaries and to set wages, whether they're hourly wages, piecework wages, or completely disconnecting time and remuneration altogether. And so for many years, for about 10 years, I did an ethnography of Uber and Lyft drivers in the Bay Area. And one of the things that emerged around 2020 was a new practice of upfront pricing. So the wages that the worker got was completely disconnected from what a consumer paid. And through that process, workers weren't able to predict how much they got paid, and they also appeared to be earning different amounts for the same work. And around this time also, a few years later, Uber's chief economists, alongside some collaborators, came out with a paper that found that Uber women drivers make less than Uber mail drivers. So even in this context of supposed, quantitative economic rationality, you see the recreation of traditional dynamics of inequality, where historically marginalized workers experience not, uplift, but in fact further immiseration, but just through and with robots. And so I'd love to talk about that more as this conversation evolves. But just to say that my concern for many years has not been the complete replacement of our jobs by robots, and in some instances certainly that will and is going to happen if we make those policy choices, because I do think that they're policy choices. For example, here in California, Governor Newsom last year vetoed bipartisan legislation that would have ensured that every long-haul truck had a driver in it, as long as they were going over a certain distance and as long as the truck weighed a certain amount. That was a political decision to destroy jobs that didn't need to be. So both, I guess, to say that I don't think it's an inevitable outcome that all jobs will be replaced by robots, but also to say that my own concerns in the research that I do with low-income workers really point to the reality that more than anything, what we should be thinking about is the further deterioration of working conditions, in particularly in low-income workplaces, that recreate and further immiserate historically marginalized communities, including women.
So on net, would you be happy or sad if all the HR function were replaced by robots?
I would be very upset.
Okay.
So short answer, definitely no right now, maybe yes in the future. So AI hiring and other functions, it's been already automated, and there's been some kind of assistance, pre-ChatGPT. And I'm not going to talk too much about hiring because this is a little bit outside what I know about. But what's interesting about AI hiring is that it has boosted hiring efficiency. Company has been growing faster because of it. And also another component is that they've grown internationally. So there are many factors. COVID obviously, yes. But there are many other factors, including remote. But AI hiring also has exacerbated international hiring, so cross-border work. So in a study that I'm working on, I've been collecting the data with the colleagues at the economics department here. We've been trying to measure the size of global work. And right now, on a very pessimistic number, it's very likely that we're talking about 4 million workers. So we've been gathering data from pretty much all the third-party HRs that advertise, that helps smaller companies to hire internationally. And by 2030, it's very likely the size of the market is going to be bigger than $10 billion, and there's going to be more than 15 million cross-border global workers, and they're all working remotely in the company. So we're not talking about gig workers. So we're talking about people that have a regular long-term jobs. So why is that interesting? So AI is creating more jobs, great. But the problem is that a lot of the client companies that are using these third parties are small companies. So that's creating a lot of labor law obligations. If you're an employer in North America, and you hire me based in Montreal, you're going to have to be dealing with Quebec employment law. Good luck with that. So the problem is that and it's very likely that employers also are going to be risking fines, and this is creating a lot of patchwork legal obligations. So now eventually a lot of serious HR companies like Employer of Records are thinking about helping their clients, within the constraint of unauthorized practice of law, how to comply with employment law obligations. So many of them are actually building very cool legal tools like predictive misclassification, also benefits and so on. I can talk a little bit about this, but we're not there yet. So the main problem is that it's boosting global labor market, but it's creating a lot of patchwork, legal obligations, a lot of difficult to access employment law, information, and that's making, it's creating a lot of risk for employers, and it's also probably decreasing employment protection for a lot of workers.
So that's super helpful. And you both said, no, you don't like AI, you want HR to be human?
When it comes to HR compliance, I'm pretty keen on the AI.
You want the AI?
For compliance. I don't know about hiring and others, but for employment law compliance, I feel like it
Okay. So
I think the EU term is a human in the loop.
Human in the loop, yeah. I mean, I don't know how
Which,
deploy it, but the bottom line now is that a lot of organizations, I mean, like, for example, let's take the example again of Canada. I mean, 99% of the companies are small businesses. They do not have an HR. They basically just don't do the job.
Right.
They don't hire a lawyer. So I'd rather have them rely on some form of a proactive AI that gives them some guidance than nothing. And we can talk about this. There's already evidence of, having the ability to harness legal information can help companies to grow faster and also provide better employment protection.
Cool. And Vinny, you make a really good point about wage discrimination. I think that's important to think through, even when we talk about hiring, like how you structure payments. But again, in the context of this conference of AI for good, I'm curious to know, I mean, I always think of this as a compared to what question, because when we talk about how difficult it is to use AI for hiring or for wage setting or for compliance, you have to have a compared to what in the mix. And if you just say, oh, I don't like it, it's bad, I'm not saying you said it, but in general, if one just reacts negatively to it, then I always say, okay, well, humans don't exactly have the best track record for being unbiased, flawless angels in this space.
So I think that this is very much, your question very much reflects my research and writing, looking at long histories of how the law has structured moral economies of work, and both how AI is comporting with and kind of disrupting how we think about those moral economies of work. So there's nothing in the law, for example, of wages in the US that says I have to make the same amount of money as Zev. If we're doing the exact same work at the exact same time in the exact same way, if he makes more, there is an inference of possible gender discrimination. But if we're just doing the same work and earning the same, and earning different amounts, there's nothing unlawful about that. But we have, through social movements, values, moral presumptions of what, if we're doing the same amount of work, what people should be earning. So if I am making a different amount than you, even if it's not based on gender or race discrimination, I might be pissed, because this is general sense that we should have equal pay for equal work, right? This has emerged out of the women's movement, it's emerged out of the labor movement. There is this value that exists. So this is what it means to have some kind of fair wage setting, salaries in the workplace. And I think AI is really disrupting this, particularly in low wage settings, where you and I can be doing the exact same thing at the exact same time, but based on what the systems learn about how much we need to be making, how much we're willing to make, maybe how many kids we have, what we're purchasing, we make different amounts. That is very, very troubling and actually creates a new problem distinct from an asshole boss who is either discriminating based on gender or just nepotism or maybe just doesn't like what I'm wearing, right? It creates a new problem that's much harder to get at. And so what I would say is that, I have a colleague at Emory University who's a sociologist and law professor who did her PhD at Columbia, and her PhD work was actually on reentry and employment. And so she says that she came at this work thinking that hiring platforms represented democratization for people who were otherwise closed out of the hiring market. Because even with ban-the-box type laws like we have in California, it's very hard for people who have criminal records to get jobs because of the kinds of, human ills that you allude to. And so in doing these interviews with people in her dissertation, she was very surprised, and it sort of shifted how she thought about things, to hear people who were trying to get jobs, who had criminal convictions continually talk about how the hiring platforms were actually closing them out of getting jobs in ways that they couldn't fully understand. So again, in both of the examples that I'm providing here, part of the problem is the opacity. It is the fact that unlike in the context of Title VII litigation, if I maybe think that discrimination is happening, I can file suit and interview the boss, get discovery, find some kind of inference of human discrimination that perhaps lends itself to a fair outcome. But if that discrimination isn't there and it's just happening in a context of a black box where I can't figure out actually why it's happening, and the reason that it's happening perhaps isn't unlawful, but fundamentally unfair in some way that we have as a society over a century decided is unfair, then how do you address those problems? And so what concerns me, and I think you hear this a lot, but this sense that if we can do something, we should do something with AI and employment, without the requisite question of what are the many plethora problems that the new problems that this is going to introduce into the workplace or whatever setting we're talking about, and whether those problems are ones that we have to address now, which I think is the answer, or ones that we can address later. Now, in the context of Uber, which is Uber and gig labor platforms that provide in-person service work, which is where I do my research, the approach was break it and fix it later. This is where we are in Silicon Valley. That's been the approach for many, many years. Break it and fix it later. 15 years ago, we were talking about trying to make Walmart work better work. With Uber drivers, we're trying to put them where Walmart workers were. It's really resulted in the degradation of working conditions, of wages, of everyday feelings of dignity, of possibility, in ways that really could have been predicted. But again, the approach was, let's deal with those problems as they arise later.
I feel like I'd throw humans under that bus before I throw the robots under that bus. And just two quick counterfactuals on the two subject matters that you mentioned, hiring people with criminal records and pay equity, which I know a tiny bit about. So the first company I founded was called Cherry Tree Data Science, which literally helped hire people with criminal records, and we helped literally hundreds of thousands of people. It was a tech AI solution that literally helped hundreds of thousands of people with criminal records get hired.
But those were decisions that you made when you're developing the tech.
Yeah,
so part of what I'm saying is that these questions, these ethical questions about the ultimate outcome that might emerge through these systems have to be made prior to the development of, like you engage in this. This is not to say that there is something, I mean, AI is a tool, tech is a tool, just like everything else is a tool. And so if we define our outcomes early on, as opposed to, creating, for example, a hiring platform that makes decisions about who to hire based on how much historically they've made, then the outcome is quite different, right? It's not this. It's like the question is not, is AI good or bad? The question is, how and when do we decide to create AI, and what are for workplace use, and to what end? So your company was called Sharing Through Data Science, and it was particularly aimed at employing formerly incarcerated people.
Yeah. So right. So but the reason it existed was for a commercial purpose. It wasn't for funsies.
Those two things can exist in the same space, right?
I know, but I think the point I'm making is that, in the context of AI for good, I think there's a lot of opportunity for using AI for good in the employment space that's sometimes overlooked, even if you have a commercial lens. So again, both Cherry Tree Data Science and Syndio are commercial ventures. Syndio has like tens or hundreds of millions of dollars worth of annual recurring revenue. Like, it's a for-profit company.
The compliance programs that he's talking about are also for-profit, and they're helping firms and workers, right, in keeping. I mean, there's not a necessary disconnect with for-profit and good. It is all about the kinds of questions that you ask to structure what kind of worlds you want to create. Like, the Uber could have been a very different company. It could have been a very different company.
Yeah, I think I want to go back to the original point that you made, Vina, earlier. Is it's when two workers are paid differently based on various reasons. I mean, these are arbitrary decisions, or it's mostly based on past, on historical data. But I think when it comes to more complex tasks, for example, determining whether someone is rightfully an independent contractor, an employee, or determining severance, fortunately, we've got metrics. Okay, we've got metrics to determine. You could argue that, courts, judge decisions are also biased, and then law will be learning from biased decisions, but at least that's the law, and that's the essence, precedent is the essence of the rule of law. And the good news or not so good news is that AI is not very good in that. I mean, there are many studies showing that the hallucination rate is kind of terrible for complex legal tasks. I mean, a lot of legal tasks like drafting and summarizations, even AI-powered highlighting is doing very well. So I think, for example, some of the product that I built when I was at Deal is helping in a very proactive way HR professionals and small companies when they hire in a different country to determine when the nature of the relationship changes and there's a risk of misclassification. And this is old school AI. This is machine learning 2015, pre-generative AI. We trained that AI in 50 legal systems, and now we're doing a randomized controlled trial with the access to Justice Lab at Harvard on determining whether, teaching labor laws, basically, whether this is helping companies to do better job at employment protection. There is another studies on South Africa where they selected, a group of 1,000 companies and just gave them employment law information newsletter, right? And they realized, like, over 5 years, these companies grew 12% time faster than those who did not receive legal information. So here there's an argument whether, providing good employment law information, actionable HR compliance, but we're not talking about hiring, we're not talking about wage, we're talking about tasks that are more complex. Obviously, there are going to be bad actors, so I just want to differentiate between these two types of functions, and right now the state of the AI is not good, right? I think there are many ways. Earlier we talked about open source, and I think for guardrails and safeguard, open source might not be the best thing. But for accessibility of AI, accessibility of customization, I do believe open source is a great solution.
Let's talk about one specific application in the HR space, which is job matching or identification of talent, right? So talent identification. For large enterprise organizations, they sometimes get, because of the internet, right? They can have tens of thousands of applications for one open rec, right? So the argument is that AI can be very, very democratizing, I think that was the term used, and help level the playing field by allowing access. But I'm curious to know, if either of you had any specific experience with either any of that, like any vendors or AI specifically in that space, if you've had any, or what your thoughts or reactions are to that. And then the follow-up question is, how should the law regulate AI for sourcing and selecting talent? Should there ever be a situation where any of that's done autonomously? I'll tell you right now, there is no, well, actually, that's not true. There are autonomous systems that have been around forever that are not AI, like call centers. Do you guys know this? Call centers are almost entirely selected by algorithms having nothing to do with an interview. Like humans don't even, they're not even in the loop at all.
I mean, I'll just, I have not worked with any of these particular job matching software programs. I would be very surprised if there weren't the same kinds of problems that we found with other large language models, the use of large language models to then the output being somehow problematic or discriminatory or foreclosing the possibility of certain people being hired, or they're just generally being problems. That said, I think that, like what you said earlier, again, is the critical point here, is that it's not that the system is inherently bad, it's like how it's deployed and alongside whom. So if alongside a job matching system, there is an HR department that ensures kinds of legal compliance with anti-discrimination laws, age discrimination laws, which becomes, I think, a huge problem in some of these contexts. Anti-disability protection laws ensures all of that, whether it's, again, through another machine learning system or preferably through the review of an attorney, then that can be really great. Saves time, you eliminate some of the bias of the interviewer, it can be fantastic. It's really about the implementation and with what kinds of safeguards that implementation takes place under.
So we'll do reactions for that, and then we'll go back to the what should
Sure.
the law do question. What's your thought or reaction just on the?
On the hiring component function, this is way outside my area of expertise, so I can't.
Yeah, but you're an academic, so everything's with you.
That's right. And law professors in particular.
In
We
particular.
know everything.
You know everything. That's right.
I would probably argue that I would side with Vina here, and I think we would have to rewrite entirely the algorithm. I mean, the method, the way we built an algorithm is mostly based on training historical data. And a lot of organizations have a reputation of making terrible decisions. So I think we would have to instill guardrails. And again, I go back to the open source community. There are plenty of projects now that will eventually allow HR professionals, legal professionals, to build or fine-tune legal AI model, language models, with no code, in plain language. And I think this is where we have to stop with this obsession with data and data, historical data. I think in law, I would say yes, because bottom line is that there's a thing called a precedent. You have to follow precedent. But when it comes, for example, I'm working with a couple of firms on helping them, we talked about this earlier there, on helping them to optimize employment termination negotiations. So when they say we've got a lot of data, right, great. But their data, I'm not gonna, it's garbage. It's all over the place. I mean, you and I have the same job. We got fired at the same time. We worked in the same experience. You make $50,000 and I'm getting $200,000. How do you want an algorithm to learn about this? So I would go back to what Vina was saying. Basically, you need to allow experts to instill their knowledge and reasoning. And I think the future of AI, human AI collaboration is not going to be so much focused on the user interaction. It's going to be also focused on building. I mean, that's what we're trying to do with this open justice community. It's fully open source, the code is there, and our users can open the hood and they're lawyers and they can refine the model and build reasoning in plain language. And I think this is where I think AI will be better. It might be there, that means that we all have very different AI systems, but there will be much more interference from the humans in how it is created, whereas now, and I think this is true for hiring, wage calculation, it's just based on history. And I don't think historical data is a good reference point.
Well, just let me make 2 quick points on that. So first, absolutely, you're referencing something that's sometimes referred to as the Amazon problem, because Amazon notoriously built a system like this, and then they realized that their past data, especially for technical roles, was disproportionately male, and things were correlated with maleness in the data. But there's a other part of that story. Amazon corrected it and did random downsampling, and frankly, completely eliminated the bias. So in my view, AI, math, I can fix that, great, that's math. Humans, very hard to find a human and go, hey, are you biased against women? And the human goes, oh, you got me. I really don't think women should be engineers. You know what, you got me, let me stray up and fly right.
But
I've never seen that.
As an advocate, I'll say that it's very difficult, and this is to answer your second question, very difficult to hold the machine accountable because of the feelings of scientific reliability, yeah, the feelings of scientific reliability, and because it's math, it can't have bias. And so I think a huge problem that necessarily needs to be addressed, and I'll get to this in a second, is finding ways, if we're going to use these systems. I mean, Amazon didn't willfully say, whoops, you know, like it was public pressure, it was bad PR, it was likely the threat of a lawsuit. I mean, these are the things that pushes an organization to make the changes. And with a company like Amazon, it's incentivized to do so in a way that, say, a hospital who is using a nursing platform for hiring might not be incentivized to fix its problems because of the fact that they're not under scrutiny, the fact that there is very little insight into what's happening in the hospital, and it becomes much harder to solve it versus traditionally when there were problems, you solved it through individual plaintiffs or class action plaintiffs who, or labor unions, or groups of workers who were able to talk about their problems at the water cooler and then go to a lawyer and litigate the case. This becomes much harder when the problems emerge through an opaque black box. So I'll say a couple of things, and so, you know, not everyone aside from us, I think, in the room is probably an expert in US labor law or employment law, but let me just say a little bit about US employment law to understand how and what kinds of legal responses we really need in this space right now to ensure the safety and dignity and security of workers. US employment and labor law is kind of a patchwork of laws, the most critical of which were passed during the New Deal. So critically, you have the Fair Labor Standards Act, establishes federal minimum wage and overtime protection, a floor which has not been raised since 2009 and is $7.25 an hour. Then you have workers' compensation laws, you have unemployment insurance laws, and you have the right to collectively organize and bargain. Then you have the laws that were the result of agitation. Those are the result of agitation during the labor agitation during the Great Depression. Then you have the laws that are the result of civil rights and social movements in 60s, 70s, 80s, and 90s. And those are Title VII, prohibition against discrimination at work based on race, sex, national origin, religion, and the Americans with Disabilities Act, which was passed in the 90s, 96, I think, and the ADEA, the Age Discrimination and Employment Act, as well as some laws protecting veteran status. So we have these sorts of, this patchwork of federal law, and those laws were passed in response to particular human demands. People needed a living wage, they fought for the Fair Labor Standards Act. They wanted to be hired and not discriminated against in the workplace, they passed Title VII, or they agitated to get Title VII passed. They wanted the workplace to accommodate them and not be excluded from the workplace. They fought to get the ADA passed, right? These are all laws that were responding to particular forms of human need. You're injured in the workplace, you need access to workers' compensation because it's so hard to sue your employer, right? So in this moment, I think there is a lot of reliance on these traditional patchwork laws, but there are also new problems that AI creates, and one of which I think Zev has really put his finger on, which is lack of transparency. So it's very hard to know when the robot has made a problem, made an issue, violated the law, created a problem. And there can be no real agitation around it because it all feels very unclear. And this is what I see with my workers that I do research with. So one, greater transparency in these contexts, which you see now in the EU context under the AI Act, under the Platform Work Directive, and certainly via GDPR, although it's not as affirmative under GDPR. And then I think we need some kinds of basic prohibitions. Again, assuming that not everyone is like Zev, going in with the idea that he's creating this commercial software with the greater good in mind. We need some blanket prohibitions on certain types of uses of AI. So again, in the EU, for Platform Work Directive says explicitly that you cannot use emotional and psychological data processing on workers. I think we need something very similar in the US for AI regulation. There is some regulation around termination. A human has to be in the loop under the GDPR. Companies that have tried to rubber stamp terminations by just having someone in Poland say, yes, this AI made a good decision to terminate this person, they've been held accountable. That is not what it means to be a human in the loop under GDPR jurisprudence. And finally, and this is something that we're moving forward with in legislation in California, in Illinois, and in Georgia. There's a big Washington Post article about this a few weeks ago that actually stems from some of the research that I've been doing. We're looking to prohibit redline algorithmic wage discrimination, so that just like labor price discrimination has long been used on the consumer side of things, the traveling of labor price discrimination to create surveillance wages, digitalized personalized wages, is something that I think broader groups of people are saying is not the kind of work that they want to do, not the kind of thing that they want to experience, and should be made unlawful. So that's sort of my take on what kinds of new laws we need and the limitations of enforcement of existing laws in the absence of more transparent systems and audit systems.
Okay, so on the regulation of AI, I would take a more measured approach when it comes to replicating what the EU did. I mean,
You have the EU legislatures in here, so be careful.
yeah. I mean, I was an EU civil servant, both European Commission, and I was a chief of staff of the vice president of the court for 5 years. So I know the EU is very good at creating very broad regulation so that the courts can actually step in and do the interpretation that they were not willing to do. So I think my take would be probably more sectoral. I mean, law societies, HR professional associations should be doing their homework, because I think a lot of the principles of the EU Act are hard to apply in practice. So let me, and I think in general, I just want to take a step back. Right now, what we've seen, the HAI index published last year showed that from 2023 to 2024, 2022 to 23, AI investment went from $3 billion to $25 billion. So I think we're pouring money into something that first has a lot of issues. So in our space, at least in my space, so legal AI and HR compliance, the studies on the performance of this system is kind of terrible. We're talking about specialized systems that have a hallucination rate between 60% and 88%. Okay, it varies in terms of tasks. And this is also true for specialized legal system coming from very reputable vendors. I'm not going to cite any of them because this is a hard problem, right? So from a performance standpoint, we haven't cracked the problem. For those of you here who are in publishing in computer science journals, it's a pretty complicated job to do right now. You submit a paper, and then when you get the review, most of what you've done, which is actually quite fast compared to law reviews, it's like a month, and it's already outdated. So I think before thinking about the regulation, we need a little bit of stability of how reliable these systems are, which is not the case. But I would even push this further. I would go back to this idea that I planted earlier about randomized controlled trial. I think we also need to think about adoption. There are recent studies showing that law firms, HR companies are very good at rolling out new functionalities. But apparently there's very little adoption. Okay, so we're building very cool products, very expensive, and that's true for our lab. We build tons of product for HR companies, and only 3 or 4 of them are very successful. So we're wasting a lot of money. Okay, and then the last question is, what is the impact we are trying to have on lawyers, on pro bono organizations? One study we're trying to do, we've been receiving a very generous grant from the Canadian government to build a very cool product for the pro bono Ontario. They receive 30,000 calls every year, right? We built a ChatGPT for law, great. An open justice with reasoning integrated and all that, but very little adoptions because we realized that a lot of the lawyers that receive calls, they don't really have time to just go through a chatbot. Also, we realized that a lot of the answers were not in the law. They're actually in their data. They've had 20,000 question and answers already answered. So we had to revamp the entire tool and realized that it was not, the impact wasn't that much better than what they were doing before. It was actually adding more work to them. So the real question is, are we helping these organizations to serve more people? And so there are many steps, I think, before thinking about policies, regulation. I mean, we're building stuff, at least, I mean, people from a technical standpoint should evaluate the reliability of these tools. Then we need to think about the impact. And then eventually we may bring back, and I think that has to be at the sectoral level, not at the federal level or the EU level. Sorry.
Well, can I ask then what you think of, I mean, the AI Act mandates precisely what you just said, depending on a risk level. So why would that not be the right federal approach? It makes you do like you have the producer, the developer of the software has to do these kinds of reliability tests periodically and ultimately under the GDPR conduct impact assessments, which are the two things that you just pointed out.
Impact assessment at the EU level, I mean,
there hasn't been good enforcement of these laws, but
okay,
the two things that you're talking about are embodied in these sort of, in these federal regulations and so, or these EU-wide regulations, so I'm curious as to what you think of them.
I think this won't be, there will be very little enforceability if this is not implemented at the sectoral level. I think this is, and we've seen that with previous regulation, I think there has to be professional associations.
So you're talking about self-regulation?
No, I'm talking about domestic, I mean, law societies, I'm talking about Ministry of Justice.
I see, like there's certifications, et cetera. It's interesting.
I think it has to be a little bit more granular.
But that's an enforcement strategy, right?
Yeah.
I mean, do you think that it would be better or worse for, I mean, well, let me back up. I think there's two things that we're talking about at the same time, and sometimes they get confused in these conversations. You know, when we talk about AI, we sometimes conflate problems that we have with data. So even if you don't have any AI, there's data that on which you're relying for making decisions, whether you're using AI or an abacus, and there are correlations in the data that exist independently of the AI.
Yeah.
So I think first and foremost, it's important to note that distinction when we talk about any type of regulation or audit or testing or anything having to do with the AI. You have to make sure you're, as you mentioned, apples to apples, right? Like I don't care if an AI is treating someone differently because they're different. I care if they're treating like candidates in a different way, independent of other things that can be, rational job-related explanations. So, transparency is really important in this space. And I mean, again, I always say compared to what, right? Because humans are not transparent.
Yeah.
Like it's very hard to like dissect what a human brain is doing and make their decisions more transparent.
Probably less transparent than a machine.
That's my point. It's significantly less transparent. So when we talk about regulating AI, we have a couple challenges. You have the data challenge, you have these opacity / transparency challenges, and then I think you also have a technical challenge, which is a lack of clear understanding of what these systems are doing. So there is a real need for subject matter experts to be involved, which in some instances is the case. I've been asked questions by legislators, and I think that's good. Now, I'm just saying I'm the only person that you should ask. You ask lots of people, but like I've had conversations with folks at the federal level in the states, at the state level, and even in Europe. And it's good that they're asking those questions and trying to ascertain things from people who are practitioners and people who actually know how to build the machines that they're trying to regulate.
I wonder if I could ask you a question about that specifically. So one of the problems that we've faced under GDPR, which does provide a certain degree of transparency and explainability rights. So there's really important cases. Worker Info Exchange brought these cases on behalf of drivers. It's an organization that represents individual drivers in litigation around GDPR, individual workers around all over the EU. They're affiliated with the ADCU, which is an app delivery courier union that itself is affiliated with the GMB in the UK. And they brought these two really important cases in Amsterdam on transparency and explainability against Uber and Ola for purposes of why drivers are terminated and how workers are paid. And the Uber, and they won, like after many, many years of litigation, which is incredible. We finally got some explainability, although it wasn't great. But what was hard about it is that because we're talking about machine learning systems, the system had already changed, right? Not only had the system changed because it's a machine learning system, but also because it was, 6 years later or whatever. And so it became fairly meaningless to the workers in practice, even though it was a huge judicial win. And so I wonder, what does, because you have both the technical expertise here, what does good transparency mean?
Yeah, that's a great question. So, and I was going to ask you guys the same question, so I'm glad you're asking me. So, the degree to which something can be transparent in this space is really there's two components. One is the degree to which the code is something that can be accessible and tested. And I've tested proprietary systems in code base, right? So let me go back. How can AI be biased, right? You said maybe math can't be biased. That's a perception. I actually don't think the term bias applies to math, but that's different. That's more of a entomological conversation, because I think bias involves some type of intent or knowledge, but that's a different question. But the idea of can it discriminate, can it cause problems is a different one that we can answer. So it can be the data, right? The data themselves. It can be the code itself, independent of the data, right? So if there's code in a system that's trying to find out who's a good employee, and it's like if male plus 10 points, right? Like problem. I don't need any data to say that's a problem with the code, right? That's an AI system that is in itself creating discriminatory impact, right? Problem. Right? So that's independent of data, which is really important. And then there's throughput in terms of how it's learning and processing and changing, right? So if the way it's independent of that code, if it has algorithmic tendencies to basically have proclivities in one way or another, that's also a problem that's much harder to get at. That's the component of transparency that's the most difficult to ascertain, because sometimes you have to observe it over time in throughput. So that's to your point about that kind of case, and things can change and it can evolve. So you're trying to train a model on how it's learning, right? So it's like teaching a child how to learn something. And what they're exposed to matters, but also how their brain works matters. That's the analog there that's really challenging to ascertain and to measure and calibrate and test. The truth is you have to just have a cadence set up. I think most of these laws don't have enough of this, but I'm a big fan of having more of not, testing isn't just one and done. We say this to clients all the time. When we talk to clients about testing AI, and they're like, well, let's test it. We're like, great, when are we gonna retest it? If you have a system that's learning and changing, yeah, it's maybe it's 6 months, every year, right? And some laws even have this built in, like the New York 144 law and other laws that are coming online are starting to think about this cadence of review, because it's not a static thing, right? It's not a static thing, which by the way is true in employment law anyway, right? Like if you make a decision based on time one, wait till time two, and now there could be discrimination at time, of course, there's statute of limitations, all those things. So I don't think it's inconsistent with existing employment law regimes, but I'm curious to know what both of you think.
Can I ask just a follow-up question? So in the cadence and review process, then ideally, is this something in the AI context, in the AI law, AI Act law, and the EU,
Right.
something like this is mandated, maybe not effectively, but it's unclear from the Act how public this has to be.
Yeah.
Who is this subject to union negotiation, union review?
I think
kind
works
of go
councils.
into your question about actual enforceability.
So I think works council, in other areas of law, works councils have to be involved, right? So for pay equity, I know, so the laws that are about pay transparency in the EU, you have to involve your works councils, right? And I think that's going to be an important component of this as well. I think it's going to carry over. So that's one thing that's really good. I think for EU versus United States, that's a big advantage they have, is works councils' participation rates are much higher. And it has another level of review, and that's great.
In certain countries.
Yeah, exactly. So I agree. But the idea that the cadence of review is going to change or be fluid, or how transparent are the actual results, this is a hotly debated topic, as you're probably aware. And here's a problem I've observed, which I'm really curious to hear what you both think about. So New York 144 requires bias audits from an independent source. Great. I've reviewed independent sources that have got it wrong. But the law says you have to publish the results. They got it, the math was wrong. I looked at it, I'm like, this is incorrect. And the client was like, well, do we have to publish incorrect results? The law doesn't say anything about whether you do or don't have to publish incorrect results. I don't know. Do you? I don't think you do, but.
But then is there a way to set it up so that the results are reviewable?
So this is right. So you see the problem, right? So you have these laws that say, yes, you have to be transparent and publish the results. okay, so you do results time one, and then you have someone review those results and go, well, these are wrong. This is
Public
demonst-"
audits or something, which is
Right.
like GDPR, right?
So, but this is the evolution of how these laws are going to be. So I think a lot of these laws, by the way, there was like a rush to try to get them out, and that's great. Like we need something, but they're clearly works in progress. I think. But what do you? I mean, please.
Yeah.
I think-
As are the systems themselves, which is part of the problem.
Yeah, and the systems are evolving. And I think the problem, I think a lot of the challenges, I go back to the original discussion we had, is that are very sector specific. I mean, what you're describing when it comes to hiring is going to be very different
Yeah.
from predicting, health, from
Yeah.
making health decisions. So I think the problem is like we're trying to build a one size fits all model.
Yeah.
And then that's going to be, and then I go back to this question of enforceability and if it's not enforceable or if it doesn't really make a lot of sense, it's putting also too much pressure. There's also the question of the burden.
Yeah.
Like, okay, an impact assessment, great, but a lot of the companies are, building the sheep as they sell.
True, but the
They don't really
plaintiffs,
have-
by the way, plaintiffs bar loves more AI because they think there's going to be more class actions on which, and there
Oh,
has been a
100%.
Well, we
ramping
can't
up
have
of
class
class
actions
actions.
in the US anymore because of Epic systems, so maybe elsewhere.
I think we have.
I think we have a question. Let's go to the audience.
Thank you for a fascinating panel. I'd like to ask a question from a completely different angle, and that is with regard to this MIT Open Courseware Centric Wiki World University school that I'm developing, planning 200 countries, major universities, and potentially coding also for wiki schools in all 7,000 languages, and then even coding for all 7.9 billion people on the planet. We'd like to code also for electronic health records and for abolition, to abolish the wrongful buying and selling of people in the illegal sex, drugs, violence, et cetera, industries internationally, and their latent networks of violence. And how that would work, for example, with AI in hiring and future of work are interesting questions. I was recently in a Quaker online meeting gathering in California, and there were some people from Nevada there, and she was working for a hotel, and she was talking about recruiting for that hotel with AI. She's doing a master's degree in data science, and potentially, for example, in California, how to protect people from, say, international organized crime with AI in this process as it develops with machine learning and in the future of work, for example. How to protect people from being, conscripted into the illegal sex, drugs, violence, weapons, et cetera, industries. Thanks.
Controversial topic. I think the panel's probably anti-buying and selling of humans, but I'll turn it over to them to answer.
I mean, it's a wonderful aspirational idea. I think that those are problems that emerge from political economy problems that AI can't fix.
It's not
But
an AI problem.
yeah, but I think that I think the closest sort of approach to identifying really exploitative systems are maybe the kinds of compliance software that Sam identified. But I mean, I think this is an organizing question. This is a social movement question, and not one that I see technology as playing a huge role in.
Sam?
I think my colleague said it all, but yes, I would probably, I've never worked in this area, but I know recently a large HR tech company was, I think, sued before the SEC for some kind of money laundering issue. And I think this is, they did not implement the right system to detect what could have been detected as, and usually, that kind of money laundering can lead also to sex trafficking and all that. So I think they just have to do a better homework tracking that kind of transaction and facilitate. And I think what you're suggesting is that we might see more of these because of HR third parties that are facilitating hiring, and when a little bit like the Uber problem. If if they're being brought, if they're being sued, they say, we're just, an intermediary. We don't really do a lot of the work, but that's their responsibility to track that. On the substance of the problem, I don't have much to say because this is outside my area.
Can we answer?
I do a lot of work, actually, or some research on slave-like conditions and labor regimes to address slave-like conditions. And there are really creative, interesting things that are happening all over the global South with the assistance of like really interesting things happening in Brazil under Lula to address slave-like conditions, but I haven't seen any kind of really interesting technological interventions here. It's really about having more labor inspectors go in and identify the problems and actually giving them police powers, really enforcing existing laws in that way.
Can we have one more question, please?
Yes. Thank you so much. This was an incredible discussion. So one observation is going back to using terms. We keep talking about AI as a tool, but it's also a product. And I think there are plenty of product liability laws already on the book, but then when an autonomous car runs over somebody, we say, oh, it was AI, we don't know what to do about it. Well, it's a product, it's not a tool. So why are those existing laws not applicable? So I think it's a red herring when a lot of companies say, oh, we need an AI regulation, because we already have a lot of laws. It's a question of framing what these things are, and I think we should have a strict liability for an autonomous car, just like we have when a regular car runs over somebody, and it shouldn't be left to the user or the consumer or the victim to show who is at fault. Let them figure it out. So if an AI agent company sells a tool to several enterprises to use it, I, as a user, shouldn't have to worry who in the food chain I have to go at. It should be joined as several liability. So I think we need to be very careful about the special interest trying to reframe the terminologies, because that's how you get away with that. So anyway, that's...
I think that's such a good point, and certainly in the media studies, communications literature, there's excellent discursive analysis of the role of, for example, the use of the word platform or the use of the word AI to advance very powerful companies' interests and to help them engage in labor arbitrage. Charlton Gillespie has written about this. I've written a little bit about this, but I do think that the language here and the way that the language sort of mystifies what's actually happening and the enforcement of existing laws is a really critical way to think about the applicability of existing laws into the space.
Yes, we don't have to reinvent the wheel. Product liability regimes already is very robust to address these issues, and we're already seeing this. I don't know if you heard of this case. Air Canada chatbot offered a $1,000 voucher, and Air Canada claimed that it was some kind of an AI. They tried to basically shift the responsibility, and then eventually they settled, but that was a pretty poor argument. There are going to be different kind of regimes. Already we see the emergence, especially when it comes to product liability in the EU, like for medical devices, they should be like stricter requirements, but overall, we don't have to reinvent the wheel.
Yeah, I think that's already happening. Like product liability law does apply, agency law applies, employment law, labor law applies. Those things are happening.
Can I make one final observation?
Oh, yeah,
I
please.
know everybody's
Sorry.
hungry, so I'm going to talk really, really quick. So AI and hiring, I think we need to understand and appreciate that it is both an outbound issue as well as an inbound issue, right? You've got human beings that are now using deep fake to show up in interviews, for example. You have individuals trying to get
System
hired for maybe a senior engineering role, and they're plagiarizing content that's on the web. So I think as we consider AI for good, right, and think of the regulatory regime and how companies are operationalizing and responding, we can't lose sight of the fact of the value of both sides of the equation. Otherwise, we're going to kind of skew ourselves too much in one direction and take away protections that are actually legitimate and for societal goods. So that's my observation.
It's a great
observation.
point.
Thank you. So please join me in thanking the panelists. And I think lunch is next.